This presentation is about the maxims and the application of the maxims under various laws. So, the first and foremost maxim which is to be discussed in this particular presentation is acta exteriora, indicant, interiora, secreta. The meaning of the maxim is acts indicate the intention. This meaning finds its existence in different forms of regulatory laws. It finds its applicability in the principle of law of contracts, law of torts, law of crimes, and various other laws which are of regulatory nature, which specify, which deals with the acts and describe whether the act is an intentional one or an unintentional one, and at the same time it extends to categorize whether the act is wrongful or is it a righteous one. But before proceeding to the applicability of this maxim under the various laws, let's discuss about the regulatory laws. Regulatory laws are those laws which are applicable in the society in order to regulate various acts and omissions, and at the same time provide sanctions by way of punishments or other means, as well as remedies to cure the consequences of such acts or omissions done with malafide intention to cause harm to the society. So these regulatory laws may be of penal nature or may be of principles nature, which are based basically on the principles only. And the mere applicability of these principles will allow these laws to regulate the acts and conducts of the people in the society. So let's move on to the first principle of applicability of the maxim acta exteriora, indicant, interiora, secreta. This maxim finds its applicability in the law of crimes, which has been enacted in the year 1860 by the name of Indian Penal Code. Recently, the Indian Penal Code has been repealed and the newly sanctioned code, Bharatiya Nyaya Sanhita 2023, has been approved by the Parliament. However, the basic nature and the fundamentals on which this particular law has been laid down has not been changed, nor it has been modified. The basic principles on which this particular law has been laid down is based on the maxim actus non facit reum nisi mens sit rea, which means it's not only the guilty act which causes the crime, but it has to be accompanied by the guilty mind. Where the act is accompanied by the guilty mind, only then the act is classified to be a crime under the Indian Penal Code 1860 or be it the Bharatiya Nyaya Sanhita 2023. So, this particular law of crimes is based on the acts and omissions. The acts in the entire code has not been defined to be wrongful because the act itself is being considered as crime and has been classified as crime, and only those acts are mentioned in the entire code. However, wherever the omission is being used, the word wrongful is pre-suffixed with the word omission, and the sole reason behind that is that not every omission amounts to a crime, but only if the omission is wrongful in nature, it will amount to a crime. Therefore, the entire code depends upon the act, and the acts being intentional in nature or unintentional in nature amounts to great significance in the entire code or in the entire Sanghita. Therefore, the maxim finds place in this particular law of crimes because it classifies certain acts done with certain intentions as crime under the entire code. Moreover, apart from the law of crimes, the maxim finds place in the law of contracts too. Contracts are nothing but the manifestation of acts done with the intention to create an obligation of the performance of the acts and omissions mentioned as significant part of the contract. Only after the performance of those acts or omissions, the performance of the contract will said to be fulfilled. Therefore, these manifestations of the intentions or the omissions which has been mentioned in the Contract Act forms a great part of this particular maxim. Likewise, it has been stated in the slide that the landmark case of Balfour versus Balfour, which forms the basis of the maxim 2, wherein it was held that it's only when the parties intend to enter in a contract the agreement becomes binding. Until and unless there is no such intention to enter in a contract, the agreement does not become binding. Therefore, in order to make the agreement enforceable into a contract, the intention of the parties must be very clear. Moreover, Section 37 of the Indian Contract Act signifies the essence of intention to perform the contract. And this intention to perform the act is an essential part of the contract laws, and therefore this particular maxim finds its place in the law of contracts too, and we can connect this maxim with the law of contracts wherever the concept of intention to do the particular act or omission in order to fulfill the performance of the contract is required. Therefore, this maxim finds place in this particular contract too. The maxim acta exteriora indicant interiora secreta, which means that the intention is manifested by the act itself, or the act clearly clarifies the intention behind the doing of that particular act. This particular maxim finds place in the law of torts also. Now, each and every tort is a consequence of the wrongful act or which makes the act tortious. It's the wrongfulness of the act which makes the act tortious. However, the act should be comprised with guilty intention does not form the essence of each and every tort. Unlike the law of crimes, in the law of torts, the presence of intention behind doing the act is essential only in certain torts, and the presence of malafide intention in doing the acts in certain torts is essential in cases of some and specific torts only. It's not that each and every tort requires a guilty mind or a guilty intention. At the same time, this particular maxim finds place in this particular law of torts in the sense that each and every act which is being done, which makes that particular act wrongful, which makes that particular act tortious, forms an essential part of the entire law of torts. However, there are certain torts like the tort of assault, battery, false imprisonment, trespass, wherein the applicability of the maxim acta exteriora indicant interiora secreta is finding its place. This is just because that these are the few torts wherein the motive, intention, and malice is required to make the act tortious. The maxim acta exteriora indicant interiora secreta finds place in the Specific Relief Act 1963 also. The law of specific relief deals with the remedies which are of specific nature and which provide specific reliefs with respect to movable properties as well as immovable properties. However, in this particular Act 1963, which is a particular branch of an extended form of contract which needs a special remedy in the form of specific relief, requires the willingness and intention to perform the act by parties as an essential and significant part of the contract. And this willingness to perform the act is manifested by the intention of the parties towards the contract. So, whenever a party does an act or omits to do a particular act, it shows the willingness of that particular party to perform the contract, and at the same time, it fulfills the obligation which has been laid down on that particular party under Section 37 of the Indian Contract Act. Also, at the same time, this particular maxim finds place in this Specific Relief Act in the sense that it manifests those acts and omissions in these Specific Relief Act 1963 by way of the fulfillment of the willingness and intention to perform the act by the parties. This is how this particular maxim finds place in a number of regulatory laws in India, be it the law of crimes, be it the law of contracts, be it the law of torts, be it the law of specific relief, and many other laws, but limited to these particular laws at this particular point of time. This particular video was intended to clarify the applicability of the maxim under these laws. We'll come up with other maxims too. Meanwhile, you can contact at shrutipande.alsn@gmail.com and can also follow at the Instagram channel lex.shruti. Appreciate your time. Thanks. And do follow, share, and subscribe.